Very good morning to all our dear audience and welcome to all of you. Thank you for joining us. And this is a great opportunity to welcome our speakers who would be today giving us plenty of insights on a very, very pertinent topic. And I think we can actually get onto a debate kind of a thing. But first one foremost important part is that we first understand what is the scenario when we are talking about contract labor, why people join and leave, and so on and so forth. So I won't steal the thunder of the conversation and insights from our speakers. So it's a great opportunity for me as a moderator to introduce the speakers. So first and foremost, I will welcome Sarmishta Roy Chaudhary. She's our speaker today, and she's ex-CHRO of Power Exchange India Limited. She has recently taken a short sabbatical to submit her thesis, and she has 22 years of strategic HRM expertise. She's led high-performing teams in diverse sectors, which include manufacturing, telecom, automobile, consulting, chemical, and power and energy. She is an MBA in Human Resources and double bachelor's degrees holders in Science Honors in Chemistry and Bachelor's in Education. She has an advanced HRM qualification from IIM Ahmedabad and is certified as trainer and facilitator, total rewards compensation and benefit analyst, leadership and change management expert. She has won Superwoman Achievers Award in World HRD Congress and Women Leadership and HR Innovation Award. Welcome, Sarmishta. Now I have the privilege of introducing Sumit Bhattacharya. He is CHRO SPM and Infra Limited. He is having 25 years of experience in HR domain. Sumit has worked in 4 countries and different industries like manufacturing, retail, IT, education, financial services, NBFCs and EPCs and infrastructure sector. He counts Astralis, sorry if I have pronounced it incorrectly, US, International Group, UK, Khadim's, Microsec, Shrey Group and Propello Group as his previous experiences. Apart from his MBA and being an XRI alumni, he has also earned 24 qualifications in different fields of HR from various foreign universities. He is specialized in talent development, organizational development, competency mapping, and psychometric assessments. As I mentioned, he's currently associated with SPML Infra as CHRO and its others group companies. Sumit is very passionate in teaching and training and is associated with many foreign universities as a guest lecturer, certified trainer, and coach. Sumit, we are so happy to welcome you. Now, a very, very dear friend and a very eminent speaker, Neerav Jagat. He is Group CHRO of Sugar Cosmetics. Neerav Jagat comes with more than 20 years of experience spanning various sectors like consulting, infrastructure, manufacturing, and e-commerce. He counts Randstad, Cerebrus Consultants, ILNFS, and NICA as his previous experiences. He was a startup advisor in his most recent gig facilitation role, which he helped to scale for early stage startups. In his most noted previous assignment, he was the Chief People Officer at NICA. Neerav was part of the leadership team that blitzscaled NICA through the steepest growth phase. Wow. Thank you, Neerav, for joining us. Welcome to the session. So I'm sure our audience is extremely, extremely excited and is looking forward to our today's conversation. And it is my definitely role to set a little bit of context and give a perspective around the topic, because we would all like to know, what's happening in this field. So in India, contract staffing is regulated by Contract Labor Regulation and Abolition Act of 1970, which governs the rights and responsibilities of both the employer and the contract worker. The act applies to an establishment that employs 20 or more workers on a contract basis and requires the employers to obtain a license from the government before engaging in contract staffing. The license is valid for a period of 5 years and must be renewed every 5 years. The employer is also required to maintain accurate records of the number of contract workers employed and the wages paid to them. Under the Act, contract workers are entitled to the same wages and benefits as regular employees during the same work and must be provided with safe and healthy working conditions. The Act also requires the employer to provide necessary safety equipment and to ensure that the work environment is free from hazards. In addition to the Contract Labor Regulation Abolition Act, contract workers in India are also protected by other laws such as Minimum Wages Act, the Payment of Wages Act, the Employee State Insurance Act, and the Employee Provident Funds and Miscellaneous Provision Acts. These laws ensure that contract workers receive fair wages and benefits and are protected against discrimination and harassment. However, there are concerned that these laws are not always enforced effectively, and that contract workers in India are often subject to poor working condition and low wages. In addition, there is a lack of clarity around the rights and responsibilities of the employer and the contract worker, which can lead to dispute and legal challenges. Despite these challenges, contract staffing continues to be a popular practice in India, particularly in the IT, ITs, and sectors. Many companies are relying on contract staffing to meet the short-term needs, such as project-based work and or seasonal fluctuation in demand. Going by this year's Republic Day theme of Jan Bhagidari, participation of people, India employer looks forward to more inclusive and participative workplace for the working population, whether permanent or contract. Thank you, India Employer Forum, for giving us this opportunity to reflect on the entire system process of contract labor, and also enlightening our audience with the help of the context we have all set together today for the conversation. And it gives us an opportunity to also relate to the experience of our eminent speakers. So I'm going to put forth few questions to all our speakers, and each one of you kindly respond from your respective background, because we're so lucky to have very diverse experiences. So my first question to all of you is, what is the on-ground reality of working condition of contract staffing and the adherence to the Contract Labor Regulation and Abolition Act? So, Sumit, would you like to go first?
Definitely. Thank you, Runa. So it's a privilege for highlighting few pointers on that. Basically, the on-ground reality, yes, we need contract laborers, but however, the act itself has certain anomalies and the gaps which can easily be where we can say if anybody wants, they can break it. First of all, the act fails to state a distinction, clear distinction between core and peripheral activities which have led to non-implementation. First point. Second, the act states that it applies to every organization, which you have also mentioned, employing 20 or more contract labor. Thus, it enables the establishment or contractor to avoid responsibility regarding the welfare of the workers by employing less than 20 workmen. So what is happening, though it is under the definition section 1 subsection 4, though few states like Maharashtra, AP, Andhra Pradesh, UP, Gujarat, Ladakh, they have made it 50 or more. But still the problem lies that contractors are engaging less than 50 and depriving the contractual employees from the welfare. Even definition 2, which is most prominent, definition 2 has been set where defining workman, it is clearly defines that out workers are excluded under the definition of workman. So post-pandemic, work from home has been established. So this can again lead to non-implementation. Third, most of the cases, establishments are taking advantages of the provisions by taking licenses in different names. Therefore, this is a perennial problem. And to curtail this problem, there should be a single window for issuing licenses. Right now, it is in different states. So one country, one CLRA has not been implemented, which lead to a problem. Penal provision in this act, it's merely 1,000 rupees fine. So what contractor or principal employer will do? They rather face the prosecution or penalties instead of following the provisions of this act. These are the fallacies. The education scheme as stated in this act is not extended enough, and as a result contract laborers are getting deprived because they are unskilled, illiterate and ignorant of their rights. And finally, there is no direct or independent provision in this act for filing claims regarding short payment or even non-payments or even illegal deduction. These claims are to be filed under the Payment of Wages Act separately or Minimum Wages Act. So that create problems regarding the applicability of these acts. Hence, these provisions should be included for better functioning of the act. Maybe the new wage code can be a remedy. So that's my takeaway. And finally, even if we refer R.K. Pandey and Steel Authority case, still the absorption of the employees into the company, that is, my question is, does the act provide the workers under it the right to be absorbed into the mechanism, into the mainstream? No, it's still in the hand of employer. Employer can decide whether to be terminated or can be absorbed. So unless it is become statutory, the topic that easy to break, yes, it is easy to break. This is my suggestion. My pointers. Thank you.
Sumit, so much thank you for giving all the highlights, especially some of the salient point where it's very easy to break and maneuver or manipulate. I think that's a very clear insight. And I think the last point when you talked about the right to absorption, that is something very, very eminent. I will come back to that later. But before that, let me go to Sarmishta and take her viewpoint. So Sarmishta, what's your thoughts on this?
Yes, thank you. And Sumit very rightly pointed out the points that, it is very diluted. I would highlight one thing is in India, most of the population, some of the population who are illiterate, who are from the backward or vulnerability class, they definitely get, and they are illiterate, so they definitely get some, employment through this contractual working. Therefore, there is a bit of economic stability and social cohesion from that front. However, they are so badly affected. I mean, they are so much exploited in our you see the central government making rules and they themselves break. You see, there are so many railway employees. They are working on contractual. What does the contract law says? It is the perennial kind of work should not be given to the contract laborers, right? But we would see, hundreds of employees are working throughout the year, and that too in a contractual under the vertical of contractual staffing. So therefore, one who is making law, sometimes we see they are breaking law. This is very significant. Secondly is also see, I was just reading an article where the Chinese smartphone manufacturing unit, that is the Hipet Technology India, they sacked without even warning. So they were about why they sacked is because these contractual workers, they were hired for certain activity and the supply stopped. Therefore, because of the shortage of the raw materials, so these people, the next day they came, they were told, you don't have any work. So the dilution and the vulnerability is so high, and there was pent up of rage, and contractual workers have many died in this incident. And this is not only one case. We know there are hundreds of cases, which is and how Sumit told that there is the clear distinction of the rule is also not there. So I think we need to focus on them. And the laws should be rigid. At the same time, the laws should also be flexible to certain extent. Now, for example, firms that employs more than 100 workers, they have to obtain the permission of state government to lay off workers. Recently, that was a law for over 15 years. Now, recently, the state government since 2015 says that it has to be raised to 300 workers. So threshold increases, which means with the 299 till 299 you can lay off without even taking government's seeking permission. So all these things are indeed clashing with the regulations, and I think there needs to be a lot of airy voicing about all these contractual part of this.
I think, Sarmishta, which is coming very clearly that where do we have the balancing act? In one way, we can probably see that there are a lot of loopholes in the law, and there is a lot of possibilities which you and Sumit are discussing to avoid the law. At the same time, there is also a requirement of giving the support. I love the way you talked about both being rigid and flexible. So when so much has happened due to pandemic, if people don't have the flexibility to manage their labor in terms of the business requirement, then obviously it's a huge burden for the employer. So I think a very, very pertinent point. Thank you, Sarmishta, for bringing that up. And Neerav, you have such a fantastic background of consulting, and when you have guided the organization at the same time, your eminent support to an organization like NICA has given all of us in this country pride in terms of as an organization like NICA. So we would love to know your perspective.
Hey, thanks, Runa. As usual, it's always lovely talking to you. Thank you, Sarmishta. I think you and Sumit have set a really high benchmark for me to match. So I'll try my best. An audience who are here, kindly hold me to a lower standard, else I shall fall significantly short. Thank you all for being here. I think it's a very pertinent topic. And let me bring this conversation to little 30,000 feet kind of view and see why was this law made in 1970, right? We didn't have this law earlier. The Factories Act predates this much earlier. So obviously there were some needs for this law to be made. What brought about the need? The commercial need, right? At this point, the manufacturers would have gone back to government and said that the industry bodies would have pressurized the government and said that we need a regulation around this. We don't want to get into the background of the need for it. So I think there is always this beautiful dance of equals between the industry and the government. Whenever this law of this kind is made, it's made in conjunction with one eye on the commercials, the business, and the relevance of it in that context, right? 1970 to now, about nearly 42 years later, is this relevant? Maybe some part of it may not, because I think the world has significantly changed since then. And that, I think, is one of the fallacies of most of the laws as well, because they are always written in a very different context. And a lot of what got written there, though with the best intent, does not hold true today. Now, when you look at contract, and I would bring in the gig workers into this as well, because I think there's a lot of buzzword around that. Why is there a need for us to really talk about this? Now, if you look at India today, is slated is actually one of the brightest spots in the world from a growth story standpoint. And we are actually creating some of the most significant commercial properties in the world. And as you do that, as a country, as an economy, as a company, there will be jobs which will be mainstream, there will be jobs which will be peripheral, and there will be jobs which will be subject to the market conditions. Now, and you can view this in concentric circles. From an organization standpoint, number one, duty of an organization is to survive for longevity and provide gainful employment to people, right? Then make profits. And thereafter comes make profits for a longer period of time, right? So if I look at that, for an organization to survive, they definitely need people. But can any organization in today's time predict exactly that the most inner circle, concentric circle with complete conviction? Answer is no, right? And I think that's where the contract labor comes in and says that, okay, fine, we will work with you to provide you that flexibility. And as with any law, this is not as airtight as we would have liked it. And hence we will experience that there will be loopholes that people will use to kind of circumvent that. So I don't want to get into the aberrations, but if you just look at the philosophy around it, I think it's to allow the organization's flexibility. It's to allow the talent flexibility to engage with multiple opportunities to work at the same time, right? You can get into 3-hour contract, 4-hour contract. Why don't you work with different sets of organizations and actually really broaden your knowledge, broaden your skills? And you can do this capsule for 2 years, build yourself very aggressively, and then go back to a full-time engagement. Now, that's another way to look at it. If we really have to address this, then I think at an industry level, we need some thinking to revisit the language of this law. And sometimes you will see that it's quite restrictive, and it all goes down to, who's challenging and, how much really the energy and the monies you have to pursue this legally, because, getting a legal recourse is not the easiest thing, right? But the point is that can we really come to a table and find a mid path? The only challenge that I see is that the environment is evolving so quickly that a solution might just live out its shelf life in about 5 years' time. And you and I both know that all our laws are at least 30, 40 years old. So I think it will require a very, very close coordination between the industry and the government to commit themselves to reviewing these laws at a periodic intervals to keep them relevant, right? Especially from the talent standpoint, if India wants to achieve what it aspires to achieve, people are, and I think, Prime Minister, Finance Minister, and everybody's actually gone said this on record, that our talent and our advantage of having young population is going to differentiate us for the next 30, 40 years. Now, if that's what you really see at a macro level, then, the rules and the policies that are going to govern how these, this advantage that you have, talent advantage you have, is going to maneuver itself over the next 30, 40 years to help you realize that dream, then it's necessary for you to commit to this kind of framework as well, right? So if people are listening to this, I think we need to have a lens to say that contract labor act is not the most relevant, but at the same time, there is a framework for us to refer to, and it helps both ways. At the same time, it can hurt both ways. And if we really have to build a robust future, then I think we should actually don a positive hat and say that, okay, whatever's the best we should do in the interest of building myself and the organization, therefore, and continue to contribute in whichever best way I can. So, I mean, that's just a limited point I have at this point. I just want to elevate the chat.
Thank you for giving such a diverse insight, Nirav, because we got many salient point regarding the law and its relevance now that we are at 2023, and there are so many already you talked about the fallacy of law, which we are still combating with. And the best part, when we talked about people still getting into the contracts of 3 to 4 hours and sometime less, sometime more. And that's where probably the rise of gig economy we are all appreciating. And we are also not looking at as a downfall or exploitation or any other such perception. Rather, we are welcoming the whole context of, you talked about gainful employment, and there is also a different set of, gain in this, when people can work in a very different manner. Of course, we are not talking about moonlighting here, but definitely when it comes to the gig economy, in fact, if you reflect the budget this year, it is also encouraging. So my next question would be a little combination of, what we're discussing, and also there is a hindsight that we are looking at quiet trends, So how do this quiet trends like quiet quitting, quiet firing, quiet hiring impact contract staffing? You know, when is contract work or gig economy a consequence of this quiet trends? So that we can do hush hush and manage somehow, or is there some other reason? And how do you really look at handling it from government standpoint, organization standpoint, and as an employee standpoint? I think any perspective would be very helpful to understand from all of you. So who would like to go first?
Uh, let me highlight a few pointers on that, since Neera brought the right thing. One is gig economy or gig workers, at the same time talent perspective. So may I? So if we see which Neera has exactly said, it's not only contract, it's all about the laws, labor laws. So labor laws and gig economy, if we stressed upon with your point, I mean the question so far I've written down. So first, let us assess the status of the gig workers. Are they independent contractors or employees? So basically, gig workers display characteristics of both employees and independent contractors. For example, let's take an example of Uber, where the company controls the collection of fares, the management of complaints, standards of conduct, and fixing of prices. Also, and many other things, which is basically showing strong characteristics of an employer-employee relationship. At the same time, Uber drivers select their work assignments, are able to refuse the client or location, they can decide their work schedule, they provide their own equipment, and often do not have an arrangement of exclusivity with one employer, all of which are the characteristics of independent contractor. So there is always a dilemma towards defining that whether independent contractors or employees. So the very nature and purpose of gig work lead to gig workers displaying the characteristics of both independent workers as well as the employees. Thus, we can say that gig workers cannot squarely or conclusively be characterized as either independent contractors or employees. So having said so, we can see this quite quickly. So even if such a categorization can be made, there exist normative reasons against such strict categorization. So here is the fallacy, and where people are taking advantage for quiet quitting and other things. So if gig workers are strictly categorized as employees, it could overburden the aggregators with overwhelming cost, like taxes, like back wages, like penalties. It makes their economic model unsustainable. In turn, this could deteriorate the consumer experience as well, reduce the number of jobs overall, and stifle their economic growth. So having said so, at the same time, categorizing gig workers as an independent contractors would lead to their continued exploitation, which Nirav has highlighted, and denial of basic employment rights. Sarmishna has highlighted on that, like overtime, like medical leave. So therefore, in resolving the gig economy dilemma, there is a need for establishing a hybrid worker. This is what my suggestion, in order to face the consequences of quiet quitting, quiet firing, quiet hiring. So that is an intermediate position between independent contractors and employees. So this would entitle gig workers to limited employment rights and benefits, entail the sharing of liability between hiring company and the gig worker, while requiring compliances with guidelines and procedures of the hiring company. So this hybrid model or categorization can improve the welfare of the gig workers, which right now is not taking care. Wow, how it can be done? By bringing them directly within the ambit of labor law and providing them with concrete rights and benefits. At the same time, as opposed to the classification of gig workers as employees, the hybrid model would sustain the flexibility of gig work that allows the economic model of such aggregators to continue to operate. So this can help us to face the consequences of quiet quitting, quiet firing, quiet hiring, even of course moonlighting. So that was my suggestion, or my takeaway.
Thank you, Sumit. It was so beautiful. We were looking at hybrid model from the car to workplace, now hybrid workers. So it's a very new terminology, which you mentioned about workers. I think they would love it because gig worker, hybrid worker, I think we can toy with these terminologies, but we understand your context very, very well. And love the Uber example. You set the context so beautifully about how people can be independent at the same time. There is such a beautiful relationship of employer-employee. I think there'll be more perspective coming from Nirav and Sarmishta on the same, point. So who would like to go for this?
Well, I can go. I have a little bit to add on to this. But Sumit, indeed, it is very innovative. That is hybrid workers, It's really very nice, very nice term. Yeah. So, talking about this gig economy, what is it? It is the exchange of the labor of money between individuals or companies via digital platform. That's about it. And it is actively to facilitate this matching between the providers and customer on a short-term payment by task basis, right? So digital economy and the platform has also boosted the gig economy in today's interest. I mean, we all use Uber, we all use Ola and all of that. And we are indeed, the Uber food has also come up very nicely. So all of these are visible. These are the visible changes to work. But then the working conditions, how they are, it is on the web-based platform and the other digital platforms. That's how. But then the classifying as self-employed, they are denied for their labor protection and employer, provided social security. So this is a very a point which is irony, I would say. So stating work requires accepting the platform in terms of service. So there is a term called crowd workers. So they crowd workers pay, evaluation, and recourse are determined by the platforms. So workers may live in different countries and they may operate accordingly. However, there was a survey that I was reading yesterday. It shows that 55% of the global North respondents were men and 45% are women. So men outnumbered the women, that's for sure. 13% of the women on a survey said that they could only work from home compared to 5% of the male. That's because women handle many other things, in terms of household work and all of that. So they are mostly work from home. So the crowd workers are mostly done by men, to some extent women, because of the supplement money from other occupations. That's what they need. That is a hybrid worker sort of thing. And which is 32% says. And that is followed by preference to work from home. 22% of the people said that. So 1 in 3 workers relied solely on crowd work. That is a report in 2018. So despite all of these, whether it is hybrid work or, adding to their moonlighting, adding to their occupation and doing something more than earning some more money, because everybody needs money, the salaries, why they do that? Because their salaries, they are paid very less salary, right? So the failure to find a steady work because of the poor ages, that could be other reason. Unpaid labor average 20 minutes per hour. Looking for work, taking unpaid qualification tests, vetting clients in online work forums and all of these. So 88% of the workers wanted 12 hours more crowd work each week. So this is data and statistics which I found exploring some journals. So the ILO, however, shows that the social protection is a real concern for these gig economy workers. Like the social platform coverage was intensely related to individuals' dependence on the crowd work. Workers were more dependent here, but individuals whom they were paid less. they did not, they are not provided with the social security or statutory, salaries. So there is no pension after retirement. Concern is workers are surveyed, they are suddenly getting rejection from their work, which may be deemed really unfair. So 9 out of 10 had their work were rejected, for which they were not paid. Some rejections were definitely justified, because not that every time, the rejection is unjustified. However, some of the rejections or most of the rejections were unjustified. So often, little or no justifications are given why they are rejected, and few options are made available for request. Therefore, what I feel is, although we need the gig workers, the crowd workers, and in a different platform, but there has to be a proper law which would take care of their payment, their salaries, or and their social security, or the pension or statutory kind of thing. And the rejection at work needs to be justified. That's how we can frame a good gig economy workers. That's my take on this.
Thank you for bringing cloud workers so explicitly, and the data points are extremely exciting, because we always have some prejudices. We don't really go deep into the research. Thank you. As a researcher, you brought that forward. And also the perspective around social exploitation and support. So I'm going to Nirav now for his point of view, because I have a lot of similar stuff to discuss with you once Nirav gives his viewpoint.
Nirav, you are in mute.
So sorry, everybody. My bad. Okay. See, if you look at all the laws are typically designed from 1950s to 1980s, 90s, right? Typically, that's typically the broad span across the world, actually. And this is typically the time when suddenly everybody started to realize that we are too many people on this earth, and safeguarding people's interests and putting enough checks and balances in place to prevent any exploitation became the norm, because there was always this belief that there are too many people chasing very few jobs, right? And this is typically a demand supply that you don't want people to be exploited, because the demand supply math has gone awry and there are just too many people out there. That math is changing today, right? If you look at the whole of Europe is degrowing in terms of population. The Americas is degrowing. Half of Asia is, overall the population in the world is going to degrow over the next 50 years. So what's going to happen is that the world over, everybody's going to start looking at where they're going to get this next talent from, because whatever population is left thereafter is going to be unemployable, because a lot of them would have actually gone beyond their active economic age, the way the government would define. So we are staring at a situation where you might have a balance being brought about between opportunities available and the people who are willing to do the job. Some sort of that is already experienced in some quarters. Now, when you add the mix of evolving technological landscape around them, the pace at which some of the jobs becoming relevant and some of the jobs becoming irrelevant is very fast today. So when we look at, and I'm just juxtaposing what Sumit and Sharmishta mentioned, is that the quiet quitting is going to be a norm if people get disinterested in the project. And that's a far shorter span in a contract environment compared to a full-time employee, right? So people would actually there want to focus on going to the next gig rather than spending time where they're not interested. So that's that. So what we talk about, the loss of productivity is going to be experienced a lot less in a contracted environment compared to a full-time employment. When I look at people wanting to build parallel careers, look at cloud computing, cloud working, remote working, gig working, I think this is going to become the norm, right? And we will do well. And I think if you read the recent budget speech, I think there is already a mention of government trying to frame, at least if not a law, but a framework on what sort of rules and regulations shall govern the gig workers. Now, they could have easily said this as a Contract Labor Act, right? But they've not said that. They've said gig workers. And there's a reason why they're saying gig workers, because that's become the reality. It got pushed through significantly because of the COVID, but the fact is that it's a reality that we are experiencing today. So the way I would look at it is there are three parties to this: organization, government, and the talent. Organizations will do well to design their staffing strategy in such a way that they do optimize this opportunity available, thereby de-risking the scale up and scale down. One, government, I think, has been fairly proactive, and they've already made indications that they won't really discuss this. So I'm hoping that the government comes to the table and brings it up and closes this as soon as possible. And I think talent should just kind of really focus on building their skills and capability. And please understand, this is going to become a free market in the future. So as much as you want the government to come to your rescue in a labor court, you are actually setting yourself for failure, because the organizations will not lose anything. The government's not going to lose anything. You are the one who's going to lose out, because you're going to be pursuing a legal case and wasting your time while you could have actually spent that time building your capabilities. So I would flip this concept and would urge the talent to focus on becoming so good at the job that they find themselves more requested for the job than being asked to leave a contract. Yeah. So yeah, that's my perspective on the three.
Thank you, Nitin. I think my next question was more about taking a viewpoint from all three of you, that what kind of law needs to be enforced to support, this rise of gig economy, and lot many had been covered, in the conversation right now. But would you like to give, a very specific, point, and it can be short, because I have few questions from audience, and also, we have 10 minutes right now to cover all the questions. So, but I'm very, very curious to know from all three of you that would you like to give some recommendation for amendment of the law, keeping in light the rise of economy? So can we have one-liner or two-liners from all of you?
So I can start. I have a little point in if Sumit wants to start, it's his, whatever. Yeah. So, just to summarize, I think we all have spoken, as Runa rightly pointed out. So it could be 6 things. One is separate enumeration exercise. This would be a periodic, there should be a periodic labor force survey to identify gig workers and estimate the gig platform and workforce separately. Second should be a larger scope beyond digitization. Operating outside the traditional employee-employer relationship allows the platform to spread across the and the sectors. So that larger scope should be provided. Then specific effects of paid leaves. So the report, in a report, it was saying that giving all workers the sick leave, paid leave, health access, insurance, these things would be useful. Then compensation, as we were pointing out, it is advised that the gig firms to give, old age retirement plans and perks, insurance, so that, even if the work-related injuries happen, they could lead to the job loss or income loss, they could manage their things. And last but not the least, maybe Platform India, like Niti Aayog suggested that Platform India project, like Startup India and all of these initiatives could be taken from the government as well as from the private sector, whoever are using you, that will ensure their security and their statutory part. That's about it.
Brilliant. Sumit.
Yeah. So basically here, which Nirav has highlighted and Sarmishta said, I'm just adding on one thing. As I already mentioned about the hybrid model. So in any case, the hybrid framework offers significant advantages, fine, especially when compared to the status of the gig worker under the 2020 labor codes, which has to be finalized, because Out of the 4 codes, gig worker finds reference only in the code on social security, perhaps section 235. This leads to the exclusion of gig workers from the benefits and protections offered by the other codes like minimum wages, occupational safety and health benefits, and overtime pay. At the same time, while the code on social security defines a gig worker, it does not offer any concrete benefit or protections and merely provides that the central government will notify schemes for gig workers in the future. So the new labor code also missed out on the opportunity to reassess the employment contract and employee independent contractor distinction, particularly in the light of the gig working. So thus the labor codes merely mask the problems plaguing the gig economy without offering any conceptual or legal resolution to the classification problems. So this fails to bring gig workers directly within the ambit of labor and employment regime in India. So this is a big gap. So therefore, therefore amendment must be there. There should be a specialized redressal mechanism under the Industrial Dispute Act. This should cover. Second, one is that. Second is trade union. So trade union, although trade union activities in India are increasingly focusing on the rights of the gig workers, the unclear status of gig workers serves as a hindrance to the registration as a trade union for organization. We all know All India Gig Workers Union. So in the absence of such registration, the trade unions will not be granted immunity from civil, from criminal, from contractual liabilities that allow them to effectively voice their demands to their employers. So these two are specifically to be taken care. And from the employer point of view, when contractor is depriving their own labors, when principal employer has provided all the payments, all the facilities, why principal employer would be under the will be penalized when they have complied all the things? That is the perennial problem. Unless this is got amended, the law is to be everybody will take the advantages of the law. This is my takeaway. So why principal employer will face the problem when they have paid all the facilities, all the point, bonus, everything to the contractor, and contractor did not give? So it should be like open and shut cases, but it is not there. So these are the 3 concrete points I would highlight over there for the amendments.
Amazing. And in fact, initially you talked about, putting the penalties, that's a big question mark. And now you concluded with this beautiful point. So Nirav, waiting for your input.
So just being mindful of time quickly, I think the government will do well to kind of create a platform, a unified platform where gig workers can register themselves, put parameters to qualify yourselves as a gig worker in terms of education and certain skills which can be listed prior over there. There could be some skill assessments which actually enables people to know that people who are here, which means basically become a marketplace for people who want to hire talent, people who want to make themselves available for contract. And there could be regulations within that, which can be a parallel system to contract labor. What country like us will do well for itself is to elevate our game from becoming cheap labor to becoming intelligent workers. So we should start differentiating ourselves in the global talent market to position ourselves as intelligent workers rather than telling people that you come to us and we'll give you cheap labor. I think we just don't have to demean ourselves to a point. So that when we start operating at a different level in the hierarchy of talent, I think the gig working will become very important. You've seen the success with UPI. We know the India stack is today so famous. Everybody loves it. Everybody wants to replicate it, but I don't think many people will successfully be able to do that. If we can make a success of UPI and have crores and crores of transactions happening per day, I don't see why something as simple as a gig worker platform cannot be done by Government of India. I think we have the intent, we have the technical capability, and just somebody putting their head to it, we should be able to have what I think is the first ever gig working platform in the world.
Nirav, thank you so much. I think very, very useful point. And I'm so intrigued to take up a question by some, the person is not named. So I wish you have done, because your question is so valid, that how can organizations ensure that contract workers are provided with appropriate training and skill development opportunities to enhance their employability and career perspective. So would you like to comment, any one of you? Because I have a question for Neerav and I have another question for Sarmishta. So either Sarmishta or Sumit, you can, respond to this. Because Rajiv wants, Neerav, you to answer his question. So I am giving this opportunity to Sumit and Sarmishta to respond to this beautiful question on training and skill development.
I think, oh, sorry.
Sharmishti, you can carry on.
Sumit, please. No, Sumit, you go on, please.
So the
That's okay.
point, only point I would say to answer these questions is transforming from informal sector to formal sector. That's the point where there are challenges, gender disparity, economic exploitation. But to answer to this question, my thing as a way forward, that transferring from informal to formal sector would be a remedial for the skill development purpose. So the moment, if what Neerav has said categorically, this talent, when we think these people are of my talent, talent is what? Talent whose knowledge, skill, abilities are not easily available in the market. Even if somebody is in third party role, if the talent is there within him, we must have to liberate the skill development facilities for them as well, because we cannot avoid contract staffing. We require, because we are operating from one state where my project is there in the border. Instead of having a permanent labor, we would go for the contractors to complete the project. But at the same time, whether they are skilled enough or not, by the definition of this act, it is quite visible that principal employer can always always assess the performance of the contract labor. So here principal employer would come forward, and in this way, by formalized from informal to formal sector, this skill development must be done.
Thank you. I'm taking next question, Sarmishta, because we have a couple of more questions and we have only 5 minutes to go. So Rajiv Kapoor asked a very long question, but very interesting one to Neerav. That CLRA, for the purpose of securing certain rights of contract labor at one side and giving liberty to hire employee for specific period of non-perennial activities, please refer section 10 on the other side, but nowhere it has given the space to reduce employer liability. But in many cases, employers are using it as tool to reduce their liabilities. What is your views on this, please? So it's for Neerav, kindly answer.
Yeah, so I think I did mention the fact that this was written way back in 1970. I don't know who could have really, differentiated perennial activity versus a non-perennial activity. And it's only gotten nearly impossible to do that today, right? Especially when you talk about the knowledge economy, it's not possible for you to differentiate perennial versus non-perennial. So the line has blurred. Are people taking advantage of that? Maybe there are people taking advantage, but what happens when people take advantage of that is that there is something called as reputation in the market within the talent, which is likely to apply to you. There are avenues, platforms where people will talk about this kind of treatment being meted out to them. So invariably, these kind of companies are actually jeopardizing the chances of attracting high quality talent towards them. So in the short term, they might think that they have, managed to reduce the cost and, save some money. But in the long run, you will find these organizations finding it extremely difficult to attract high quality talent. And I'm yet to come across an organization that has actually made money or been successful by compromising on talent. So it's a sum zero game, Rajiv.
Thank you, Neerav. And Sarmishta, to you, a very, again, important question. What role can technology play in improving transparency and accountability of contract staffing arrangements? Nice question.
Very, very great question. So what is the question? It is like what digital transformation can do. Is that it?
Technology, how? I mean, you mentioned about the cloud worker and the way we are utilizing for work from home, the digital transformation. But this particular question is on how technology play in improving the transparency and accountability of contract staffing arrangement.
Absolutely. I think technology has to do a lot because everything right now is getting digitized, right? So technology obviously has a critical and great role to play. So if we manage even the performance of the currently we only manage the performance of our full-time employees. So if we manage the performance of the contractual workers, if we take the talent to digitization, and we make various reports and analytics, I think the transparency in terms of their performance, in terms of their training, in terms of their salaries, in terms of their wages, everything could be done in a very, very clear and transparent way. And this will help enable to understand what role these contractual, and also a very everything has to be open. Like, for example, and organizations nowadays is getting into more of an open door policy. So even for the permanent staffing, nowadays you see the offices are more open areas, right? So similarly, if this open door or open culture is instituted for the contractual workers also, I think that will be very, very transparent, and people would be. So everything needs to have a reporting mechanism digitized through their feedback, and this will inculcate and they should also have, we have some Zoom meetings, we have monthly, weekly meetings. So people, as per their availability, if they can also join along with the permanent workers, permanent employees, and share their moments of truth, share their problems, their challenges, and address to the upper management, I think this will inculcate a more cohesive culture, and this will also inculcate more of team. And that's how, as Neerav was saying, with the talent can increase, and this will bring more productivity to the organization.
Thanks. I think we're all trying to conclude the balancing act, talent advantage, and introducing very prominent legal matters in terms as an amendment, because there are a lot of loopholes. But one line, because I have only 1 minute, and I really want you to kind of come as a bullet point. And the question is quite like, putting ourselves on the crystal ball, that any idea when new labor codes are going to be implemented? I wonder who has the answer. Any point before I thank you all and conclude?
The same question is having within me, even after attending so many seminars, still I am searching for that answer.
Same here. Any point you would like to make Neerav a service on this?
Okay, I hope you're not sharing this with Nirmala Sitharaman, but yeah, the cost of, and thankfully you qualified this as crystal gazing. So I think maybe in a year's time, about 12 months.
But it has to come, Neerav, it has to come. Otherwise, otherwise it would create a huge issue. It has to come.
Yeah, no, I agree.
Surely.
If we voice it, the more we voice it, the more we air it, I think the exigency would arise, and that's how we can have this law.
Makes sense.
Absolutely, Sarmishta. I think that was a point, because we, India Employer Forum, has already taken up labor code as a subject for a webinar previously, and this question is coming up again and again. And I love the way you all said that voice more, demand more, and ensure that if you have so much hard work has gone, why not go ahead and implement and help us? So I think the today's conversations was extremely helpful. Loads of learning. I think I was kind of putting notes on my notebook, because I personally learned a lot, and we're 100% sure our live audience on social media are, and kindly all of you have joined the beautiful audience on Zoom. So thank you, Neerav, thank you, Sumit, thank you, Sarmishta, for joining us and giving your experience and such fantastic sharing your thought leadership. Thank you so much. And everyone, audience, thank you for joining us.